Good morning. I see we have nearly everybody here. I don't know if there's a problem with Mr. Emmerich or he's just waiting for exactly 10:02 or something.
For some reason, my video is not coming on. I keep clicking start video, but it's not working.
All right. Do you want to see if you can get that going, or are you all right if we can hear you? It's up
I'm
to you.
okay either way.
You can see us. We just can't see you.
That is the situation that I'm having on my end right now. And
All
like I
right.
can mute and unmute myself. I just, for some reason, the video, I don't know if the court, has a block on me or anything like that.
I don't think so. I don't know of that anyway. We'll presume it's an innocent technical problem. So we will keep an eye on you, and we'll keep an eye on where you should be. And if it looks like you dropped off, we'll come back around and just wait till you can reconnect.
Thank you.
Same goes for everybody. So with that having been said, welcome to an oral argument session here before the 5th District Court of Appeal. I'm Judge Jim Edwards. Joining me on the panel are Judge Meredith Sasso and Judge Carrie Ann Wozniak. We have one case on the docket this morning, and that's Green versus Green. That's case number 21-821. If you have a noise-making device, please put it on low volume. Don't necessarily turn it all the way off, because again, if we happen to drop somebody, our clerk or IT people may be giving you a call to help you reconnect. Typically with the appellant, we give 5 minutes rebuttal. If you'd like anything different than that, just let us know. We'll be happy to do it. There is a clock in one of our windows. If I see you're getting into your rebuttal time and don't seem to be paying attention to that, I may give you a little heads up so that you don't run out of time. When the yellow light comes on and it says 15 minutes, you're into your rebuttal time after that. So with no further ado, counsel for appellant, you may proceed.
May it please the court, Carlton Pierce of Carlton Pierce, PA. I represent the appellant, Sabrina Alston Green. In the very beginning, issue 3 is going to be abandoned, so I will not discuss issue 3 today, and I will not present any information on issue 3. I'd like to start with a judgment. A void judgment can be attacked at any time. Also, fundamental error has been defined as error that goes to the essence of a fair and impartial trial.
What is the basis for claiming? Excuse me. What's the basis for claiming that the judgment is void?
Well, the judge, the recused judge, actually called my client's former counsel as a witness, and this was after former counsel withdrew from the case.
And what case says that renders the judgment void?
Well, the case that I was about to go into was Sparks v. State.
Right.
And in Sparks v. State, for example, they were talking about fundamental error, which can be raised on the first time on appeal. I mentioned Sparks v. State in my brief. I did not go in and analyze that specific case. I pulled out some of the information which showed in the brief, but Sparks v. State is pretty much on point. I didn't, as I stated, I looked at it and I cited to it, but it went directly through with fundamental error.
So your argument is that anytime a court calls a former counsel to testify, that makes the judgment void?
No, I wouldn't say that, because a judge can call former counsel to testify about attorney's fees at a sanctions hearing or something like that. It's whether or not that judge is calling it to either tip the balance or in favor of another client. Specifically, as in Sparks v. State, there was an issue that was presented, and it was impeachment evidence that the prosecutor never used, did not request to use that. However, what happened, the judge pointed that out, went back, and the prosecutor then used that information. The client was convicted when it went back up on appeal.
Here we have no idea what counsel testified to during the prior hearing, because there's no transcript.
You're correct. However, we do know that the judge called former counsel as a witness pursuant to the court minutes. I would dare say that's the ultimate record of what happens in the court. I mean,
I dare say I have to disagree with you. The ultimate record of what's in the court is a transcript, not the court minutes. Those are, I wouldn't say they're the worst, but they're summary at best. And, again, you have an appeal, a final judgment that could have been appealed and was not appealed.
Judge, I fully understand as far as Applegate v. Barnett Bank, no one's going to argue that. But what I'm saying is that as far as, maybe I misstated when I said it's the ultimate, obviously the transcript would be the ultimate. However, what the court minutes do tell us is that former counsel, my client's former counsel, was called as a witness by the court. There is not a subpoena in the record. There was not a petition filed with this court, so apparently there was no objection from former counsel. There is nothing in the record that demonstrates that it was requested by the appellee or the appellee's counsel. But we do know that she appeared as a witness for the court, and the court minutes clearly direct that. There is nothing in the record that would demonstrate that former counsel should be there. And the claim in the motion was that she was there and she testified against her. We're looking at whether or not there's a colorable claim for any type of violation or fundamental error. So that's the issue that's really before the court, whether or not there's a colorable claim pursuant to 12.540. I haven't gotten to that point yet. However, yes, I do believe that it would be fundamental error for someone to call someone former counsel, as alleged in the motion, call someone former counsel to testify against them. And it's properly under oath, and that is exactly what my client has stated that has occurred. Anytime that this occurs, the judge's neutrality is going to be called into question. And the issue here is that it goes directly to the heart of the matter about whether or not there was an issue that was presented and whether or not my client signed a particular document. She's stating that she didn't.
No, there's not really any, there's the final judgment resolved whether or not your client entered into the mediation agreement and the underlying sub-agreements, if you will. That was determined during the final hearing, that your client had notice of, that your client attended, that your client participated in, and the court specifically found that it was entered into freely and voluntarily. So, I mean, that matter has been determined.
The court also stated that my client signed that parenting plan. Her signature doesn't appear on there. So I understand what the court is saying.
Which is why you take an appeal if the judge makes a mistake, or you move for rehearing if the judge makes a mistake. But that doesn't, the fact that the judge may have gotten something mistaken is exactly what rehearing is for. If something was overlooked or misstated, that's what motions are for rehearing are for. You can't ignore the opportunity to take that advantage of pointing out the error so the judge can correct it.
Yes, I fully understand your point. I'm fully aware of 12.530. I'm looking at whether or not there, and specifically now, again, if it is a void judgment or if the court behaved in such a manner where it was not impartial as it was supposed to have been, then that should be an issue specifically to be determined by an evidentiary hearing, especially since the 12.540 motion was done in compliance. Now, there's no question 12.530, the motion for rehearing was not done. I'm not going to argue that point. However, I'm still stating that the 12.540 motion should have been entitled to a hearing, especially considering that the order itself on the 12.540 motion does not touch whether or not the fact that former counsel was called as a witness by the trial court, whether or not that is, in fact, I believe it's harmful error, but whether or not that would entitle my client to have the matter reheard and to have the judgment set aside. Now, I know the court's saying a properly scheduled 12.530. In a particular case, that was in the Garcia case. In the Garcia case, something very similar but not exact happened. In Garcia, he claimed that he did not get the order until the 40th day or 45th day. I can't remember the exact number. He stated that he didn't get the order. And then he filed an appeal. And of course, the court stated, no, you'd have to proceed under 1.540. And it should have been 12.540 at the time, but proceed under 1.540. He filed that motion and the judge summarily denied it. The judge did not get to the issue of whether or not he had actually demonstrated the case or whether or not it was a colorable case. It only has to be colorable, whether or not there was a colorable claim of relief that was there. Well, the trial court in that case did not address the merits of the contention that he did not receive the prior order in time to file an appeal. Similarly, in this case, the trial court wrote a very extensive order in this case. However, the trial court did not get to appellant's constitutional due process rights and the fact that her claim is that they were violated when her former counsel was called as a witness against her. I believe that's evidentiary matter. I believe that 12.540 would demonstrate that an evidentiary matter hearing should have occurred to determine whether or not that allegation is, whether or not she can prove that.
In terms of due process, you're saying the only issue that had not been determined by the trial court was whether calling your client's prior attorney as a witness during trial, whether that violated your client's due process, correct?
No, that's not what I'm saying. It's whether or not the judge went beyond, whether or not the judge specifically called in her former counsel to testify against her at that hearing. And
but again, we don't have a transcript, so we don't know what the purpose of her testimony or what she testified to, or whether your client who did attend that hearing objected to the testimony or possibly waived it and said, okay, it's fine if she testified. We don't have the transcript, so we can't tell any of that, correct?
Those were several different statements. I'll break them up when I respond. One, correct, there was not a transcript. Two, we do not know exactly what was stated. Three, the fact that she waived it or not, we do not know. However, again, as the case law states, fundamental error can be raised even on the first time on appeal. So
you can't demonstrate without a transcript or a substitute for a transcript, and without knowing whether or not your client objected, you're not able to show error at all, much less fundamental error. I mean, that's a problem. I mean, I understand your client is not satisfied with the way her dissolution was handled and the outcome of it. And, you know, I understand that she wishes there were a remedy for that. But in looking at the various motions that have been filed, one says she did not file it. One says, even assuming she signed the agreement inadvertently, and then there's another statement somewhere else where she says up until February 5th, she thought you could back out of a contract anytime before final judgment. So this is not some kind of clear-cut case where we can just look at what we do have and go, well, clearly she didn't sign it. Clearly it's the judge was not impartial by having the attorney testify. I mean, it's not that kind of record that is here before us.
Judge, when the court says it's not a very clear record, I understand what the court is saying, specifically what the court just articulated. But again, I have to go back to the specific case law about whether or not there's a colorable claim. It appears that so the issue is whether or not there's a colorable claim there. And the claim inside the motion, I think that's very clear what it says. I understand what the court said, the other parts of the motion. I fully understand what the court says there. But paragraph 14 is very, very clear as far as the allegation that the court specifically called her former counsel as a witness to testify against her. That allegation is clearly evidentiary in nature. And moreover, that allegation, if true, as the court stated, we don't know, we don't have a transcript. But I think that we would need to know. And the only way to find that out would be with an evidentiary hearing pursuant to 12.540. Excuse me, so let me continue from there. Now, what happened in Garcia, when the court did not address those matters, the appellate court held that an evidentiary hearing was required as the motion was facially sufficient and presented a colorable claim for relief. That was, Garcia is actually the 5th district. And this case is similar to Garcia, where there's a colorable claim that the judge called the client's former counsel as a witness to testify against her. And pursuant to that, I believe that the relief of an evidentiary hearing should be granted by this court. I'm getting close to the 5 minutes. I'd like to reserve the remaining time for rebuttal.
All right, that's fine. You can do that. And Mr. Emmerich, if you can hear us, you're up and we'll hear from you now.
Thank you, Your Honor.
Mr. Pierce, maybe before you get too far, Mr. Pierce, thank you. I was going to suggest you mute yourself. Sometimes we get a little extra noise. Okay, go ahead, Mr. Emmerich. Thank you.
I apologize. My video is still not working, but if it may please the court, Edward Emmerich on behalf of Denval Green, the appellee in this matter. A synopsis of our position is that first and foremost, there was not a colorable argument in the motion to set aside, in that the issues alleged in the actual motion to set aside wouldn't create a colorable argument for voidness in the first place. 1.540, which was cited by the motion, or 12.540, which would be the appropriate rule, provides that a motion to set aside under the rule can be brought relating to voidness of a final judgment. However, all of the allegations made based on case law present a claim that the final judgment was in fact voidable rather than void, which kind of creates an issue with regard to whether or not there's any colorable argument that it would appear from the court's order the court was able to determine from the face of the motion to set aside, and as a result, render a ruling without a hearing. And the same goes for the second claim in this case, that there was newly discovered evidence. From a review of the court file, you can see that the final hearing took place on February 5th, 2021. There was a letter completed that is the newly discovered evidence alleged in this case on Monday, August 3rd, 2020. So there's a full 6-month period of time between the date the letter was completed and the date of the trial. During that time period, Appellee's counsel filed a request for production, which appellant responded to. Appellant had the same ability to discover that. One of the requirements of 1.540, or as more appropriate, 12.540, for newly discovered evidence to be considered and have a colorable argument is that that evidence would not have been discovered by due diligence in time to move for a new trial or rehearing. And that allegation is actually not specifically in the motion to set aside, that due diligence would not have allowed for the discovery of this. And further, there's an implication that the counsel for Appley had some duty to produce this. However, there was no specific request, no discovery request, which both goes to that the fact that due diligence could have led to the discovery of this evidence, and that there is not actually an appealable issue here because the discovery was never requested. In addition to that argument, we have the due process issue that opposing party or opposing counsel has tried to bring up in this case, and the fundamental error allegation. It is our position that fundamental error is a type of argument that should be reserved for situations based on the case law that indicate that a hearing basically should have never taken place in the first place, such as a situation where the court lacks subject matter jurisdiction, or as in the Garcia case that was cited, you have a scenario where a party did not receive notice of a hearing and did not appear at that hearing. In both of those circumstances, that hearing never should have occurred. In this case, people had appropriate notice. This litigation had been continuing for some time. There was an 1 hour and 20-minute hearing, according to the court minutes. And at the conclusion of that hearing, a ruling was rendered, which is why I suspect the third issue is not going to be addressed today by Appley. So in this particular case, we don't have the same type of fundamental error that has been referenced in other cases where the court has allowed arguments to be brought up for the first time on appeal.
Counsel, in those cases that you're bringing up as examples, is it your position that the judgments are void or voidable in those situations?
In a situation where there is no subject matter jurisdiction whatsoever, the judgment was found to be void. And in the situation where there is no notice whatsoever, that is such a large error. And this, in fact, the case law distinguishes between improper notice, like an issue with service, versus an actual failure of service to occur. So insufficiency of service of process is distinguished from an actual lack of service of process. But where there isn't a lack of notice altogether, that can be a fundamental error based on the cases that I reviewed in preparation for today's argument.
And that would make the judgment void? Or
if there was no notice whatsoever, it would make the judgment void. However, if there was notice, but that notice was legally insufficient, that would be voidable.
Because a party could probably waive that that argument, waive the improper notice.
Yes. So like if I was served on a Sunday, that would be an issue where I have notice, but it's legally insufficient, versus a situation where somebody wasn't served at all. If the court doesn't have any further questions, or if the court does have further questions, I'd like to address those now. Otherwise, I'm not going to take up any more of your time.
All right, I'm fine. Do either one of my colleagues have questions? All right, no. Mr. Pierce, we're back to you then. You have a little over 5 minutes for your rebuttal, 5.5.
Oh, I'll stick directly to what was stated specifically as far as the notice is concerned. There was a notice of hearing, but the one thing that my client was not put on notice was that her former counsel was going to come into court and testify against her. There was, again, there's no subpoena there. There's nothing demonstrating that she was going to be placed on notice of that. There's nothing stating that she waived any type of attorney-client privilege. In the record, there is nothing that she waived the mediation privilege. By the very nature of the findings of the court order, there would have had to have been some discussion about what transpired between my client and her former counsel and what occurred at mediation. There were no waivers put in about the mediation, and those waivers would have to be in writing pursuant to the statutory provision. And also, as far as the waiver of the attorney-client privilege, the judge who actually wrote this order, when her trial counsel wanted to call the former counsel as a witness, that judge made that trial attorney get a waiver specifically of the attorney-client privilege and to have that filed in the court. That does not appear. So we believe that there was fundamental error. Her due process rights were violated. They violated the attorney-client, and we're going directly from what the motion says, violated attorney-client privilege, also violated her right against her home counsel, former counsel, being called to testify against her. Pursuant to 12.540 and Garcia, we believe that the motion itself states a colorable claim and that the matter should be remanded in order to have an evidentiary hearing on the motion to set aside the final judgment.
Right. Thank you very much. If you have concluded, then we will be in recess. Thank you, counsel.
Thank you.
Thank you.